All right, good morning, everybody, and welcome to an oral argument session of the Sixth District Court of Appeal. Before I introduce myself and the panel, I would like to advise that this is being streamed live on YouTube. Please be mindful of that. And also, if you haven't yet silenced your cell phones, I'd be truly grateful if you did. My name's Dan Traber. I'll be the presiding judge today. I'm joined on my right, your left, by the Honorable Mary Nardella, and on my left, your right, by the Honorable Petra Brownlee. We have two cases on today's docket. And the first is KD versus State of Florida. It's 23-3918. Mr. Upson, good morning. 5 minutes is standard, sir, for rebuttal. Would you like more or less?
5 is what I was going to request, Your Honor.
Whenever you're ready, sir.
May it please the court, counsel, Keith Upson for appellant KD. Good morning. We have an evidence code to ensure the reliability of what finders of fact may consider. Specifically, Chapter 90 of the Florida statutes, which no trial judge may disregard. For the state to avail itself of an exception to the hearsay statute, strict compliance with such an exception is required and was absent here. I'd like to, perhaps unusually, start by acknowledging what may be the most incriminating portion of the record and transcript that's before the court for review today. Specifically, the same basis that the trial judge here used to justify his finding of delinquency as to the 4 counts, which I believe this language is at record or transcript page 120. But specifically what the judge said was, or to paraphrase, that the specific basis was in reviewing the statement that the juvenile had given. He did admit saving these 4 things to his phone, which he later deleted. I believe KD first said that at transcript page 98. I don't believe we have that exhibit in the record, but it was entered into evidence and it was published, and we have what appears to be a clear transcript from trial of the transcript of the interview. And I believe at page 98, appellant was asked, when you looked at these, did you save them anywhere to your phone? To which the response was, yeah, but I deleted it. Interestingly, it was 7 pages before page 91 of the transcript where the officer said, I'm going to show you 4 still images. Now, it's not entirely clear from that interview, but when you take the judge's order and basis finding of delinquency that he had reviewed the videos, I think it can reasonably be inferred that those 4 stills law enforcement had captured from the 4 videos that are at issue. It continued a little at 104 when KD again said, I used to, but I deleted to my phone, and then words to the effect of I deleted them completely off my phone. So here's why I'd want to do that. That's not. But those stills didn't just magically appear at some point. Nor does the defendant's, the appellant's statement, yes, I've seen those before and I saved them to my phone. That doesn't cure the evidentiary issue that the state was required to prove up, to present sufficient admissible evidence to the trial court before we could get to and consider that admission. I believe the case cited for that proposition in the initial brief, and perhaps the reply as well. I'm going to spell it out because it's the initials XS, which if I just say sounds like I'm saying XS. But I believe that was the case that said, notwithstanding the juvenile's admissions, I believe it was also a firearm case. So factually some distinctions. However, I believe in excess, the court said, I believe it was a constructive possession of the firearm case, which is even more tenuous a nexus than that was required. This had to be actual possession. He had to have been found delinquent. The state was required to have proven that KD exercised control, which saving to his phone and then subsequently deleting satisfies. But we can't just step over the evidentiary. There still has to be a corpus. There still has to be separate independent evidence.
Counsel, understanding your corpus electi argument, can you speak to procedural prejudice? If we were to find that there was a discovery violation, can you speak to procedural prejudice that was suffered?
At the trial level proceeding, Your Honor?
Yes, sir.
Want to make sure.
Yes, counsel.
And
How would you have prepared your case differently? Can you speak to that?
I cannot. Nor do I believe the law requires me to. I wasn't a trial counsel for starters, but under this court's case, Young's, I'm doing that without looking down. And it is also cited in the brief, and Your Honor may not appreciate I believe you were on that panel, Your Honor. Even the mere possibility of the discovery violation triggered the trial court's requirement to hold the Richardson hearing, which didn't take place here.
But it didn't take place, correct? Because the court found there was no discovery violation. So if that finding was an error, and then presumably if you would like us to say that was error and therefore the trial judge should have walked through the remainder of the Richardson hearing analysis, walk through all of those factors. Do you think then through that you would never have to show procedural prejudice?
And the Richardson issues intermingled with the second issue raised on appeal. I appreciate I am not answering your question directly because I had chosen to spend the time talking about the fact that child pornography cannot and will not ever be a business record. Therefore,
What if we were really interested in the discovery aspect?
well, of course, I'm merely acknowledging that I don't get to ask the questions or to find the narrative. So it's just taking me another minute to process the.
Well, so would it, if you were going to win on the discovery issue, and I'm not saying you are or aren't, but you're asking us to reverse on that point, right? To find that the trial court erred in failing to conduct a Richardson hearing. And the reason the trial judge did not conduct a Richardson hearing presumably is because the trial court found that there was no discovery violation and therefore no need to continue. Wouldn't you though then have to show us you could have satisfied the factors associated with Richardson that Richardson requires us to consider, or would have required the trial court to consider?
Not my reading of Young, Your Honor. If it were that simple, if the court could summarily say, well, based on what I've heard, I find no violation and bypass the necessity of going through those steps. Because in Young, this court wasn't ambiguous.
Which portion of Young are you relying on?
I can tell you that exactly, Your Honor. So let me.
And counsel, while you're looking, I understand your argument as to burden. I do. That's not lost on us. I just didn't know if you had any obvious procedural prejudice that you would want this court to consider.
On the discovery violation, Your Honor, again, to clarify,
Yes, sir.
I don't see how appellate counsel could possibly do that.
But whether you represented this child below or on appeal, you have to make the argument unless you're saying you don't have to make it because you can't make it. So in other words, I think what we're asking you to do is from the perspective of your client, make a procedural prejudice argument. And if you can't do that, just say you can't. But if you can, then we'd love to hear what that is.
And I think part of my difficulty is the harmlessness test on the failure to have a Richardson here procedure at all is a different harmlessness standard that doesn't require like the substance of what I understand the court is asking. Specifically, what would he have done any differently?
Well, isn't that the procedural prejudice that the defense would have to show?
Through the course of the Richardson proceeding that never took place.
So you're saying we can't find it in the record and therefore we shouldn't consider it?
The court precluded the opportunity to do so. it would be helpful if they had the Richardson hearing and then it was denied. I mean, then I would be arguing why the court didn't properly consider, but the court precludes it. No, we're not going to do any of this. And I was able to find the portion from Young. It's sandwiched somewhere between page 1248 and 1249 under a heading that begins, helpfully Richardson hearings. Anytime a trial court is alerted during a criminal trial to a possible discovery violation by the state, the trial court is required to conduct a Richardson hearing. The trial court need not be certain that a discovery violation occurred to hold the hearing. Rather, if the trial court is informed of the possibility, and that's in italics.
In that case, is the initial question for that Richardson hearing, whether there was a discovery violation at all?
Correct, Your Honor.
So it's the first consideration. So maybe whether we dub that initial factor for consideration, part of the Richardson hearing might just be where we're talking past each other on it. I think we're saying the same thing. The first thing that the trial court is required to consider is, was there a discovery violation at all? And only then do you reach the other factors.
Well, now
Or
let me, to the extent I was just nodding in agreement, let me recede from that. I read, interpret, and argue it more broadly. That at the moment defense counsel said, we don't have this, we don't know what's on it, that was the triggering event. And that it was only through the steps set out in Richardson. And it's a different, I am arguing, and I believe it's consistent with the authority, the complete failure to go through that process entirely is handled differently by us. It's not the same abuse of the trial court's discretion. It's near Herculean to overcome. It's almost impossible at this point for the state to establish that no harmful error occurred.
Got it. So you're reading Young to say that we've basically overruled, I'm not saying this in a difficult way, although it's going to come across that way. You're saying that basically Young tacitly overrules the Florida Supreme Court precedent that says that we look at procedural prejudice in these instances. Not to mention the statute that says that error has to be harmful in order to be reversed.
Not at all,
Okay,
Your Honor.
then I'm missing that because if you're reading Young to say that there's no showing of harmfulness in the error, that raises my concerns about Florida Supreme Court precedent, which of course is binding on us. And then the harmless error statute, which of course is binding.
Of course, Your Honor. But the paraphrase, though the word special standard, or it's not your run-of-the-mill abuse of the trial court's discretion, those aren't original words. I don't have the ability to put my finger on that authority as I stand here, but it does still require, it's more like a burden shifting. It's not that there has to be, it's not a per se error. That if defense counsel said, I'm not arguing it's per se, that if defense counsel says, I don't have this is a discovery violation, then the trial court must suddenly robotically go into, we're going to do Richardson, notwithstanding the fact that, for example, if you can turn to a certain page and say, well, no, they disclosed all of that to you right here. They said, these are the documents and exhibits we intend to use at this proceeding, which you won't find in this record because they hit a thing within a thing, which is not close enough. Nor is appellee's assertion in the answer brief that, well, I mean, it was a final hearing on possession. It was reasonable for him to expect that we would be introducing evidence of possession. That's not how Florida Rule of Criminal Procedure 3220B and its subparts. It's the onus is not on the defendant to suss out or figure out what documents and exhibit the state's going to try and present at trial.
No, but isn't it then throughout that Richardson inquiry, isn't it the defendant's burden to say, this is a violation and it affected me and here's how. I had no idea, Judge, for example, and it doesn't apply here, but for example, I could have used the opportunity to depose that officer, to have something that this person would have done differently, or say you have an alibi defense and all of a sudden they have a new witness and now we have to switch the entire defense theory the morning of trial. If there's nothing like that, wouldn't we just, even if we agreed with you that there was a discovery violation, would we just be, remanding a case for because there's no reason though, if the
For further-
defense isn't prejudiced,
For further proceedings so that we can have him create that record.
just so that he can, but whose burden is it to produce that record?
It was the court's obligation to hold the proceeding, at which point defense counsel would have articulated the hows and whys and whats of what would have been done differently. And I think part of my hesitation, I don't have any trouble contending that a procedural violation took place, but I'm not going to fabricate, I'm not in any position. Counsel was very clear throughout the proceedings about what had been produced and what had not, including a negative response on items pursuant to search warrant, which is exactly what this was.
Gonna go back and look at your reading of Young. But isn't it just as easy as it was literally the only other thing connecting this child to this pornography other than his confession? I mean, how hard is that? If you don't have that, why wouldn't you prepare your case differently?
And I'm not in any position at this level of review to provide hypothetical.
Right. So counsel, is it fair to say your position is that's the question that the state must answer and they must do so on a very high burden beyond a reasonable doubt that it would not have affected?
Whereas here, they were denied the opportunity, absolutely, the state has to. But I don't anticipate, and of course, I can't speak for opposing counsel, I don't anticipate that there will be factual particulars of how defense counsel coulda, woulda, shoulda done things differently. It's speculative, I think it's unnecessary. Whereas here, the court refused to have the hearing.
Counsel, how should this have been listed in the disclosure? When they were disclosing the evidence that was submitted in Exhibit 2, how should it have been listed?
Well, clearly the rules are special and they can't copy it and disseminate it and give over. They can't do an electronic file drop, but it needed to be just like in any discovery disclosure in any case.
If you
with
were the
enough-
state, what would you have said?
The video names that appear much later, and it's the hashtag or it's a really long, it's an alphanumeric that appear later, not in the charging document. That would have video 14 minutes, file name, blah, 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 that appears to depict. I mean, it's basic discovery. You have to tell the other side with enough sufficiency for them to be able to look at it and go, oh, that's a video of a criminal act that I'm not allowed a copy.
So the Marco Island Police Report is not in the record, but it is talked about in the transcript. It appears to say something to the effect of USB with, I don't remember if it uses search warrant or subpoena returns from Kik. If they had just said that, USB with search warrant returns from Kik, would that have been sufficient?
It's not. Even though there's just one state and law enforcement can, in some instances, be considered a state agent. The actual discovery disclosure that we do have has a it says reports, and then there's a parenthetical with a word salad of abbreviations, one of which is the Marco Island Police Report. So you'd have to look at that, and then, which facially doesn't satisfy 3220. That's not.
Can I
can't just
stop
say
right
it.
there? Are we under 3220 or are we under 8.060 for the juvenile rules?
3220, the discovery rules apply the same through I believe, and of course, whatever the rules say or what the rules will control my beliefs. But unless otherwise preempted or otherwise different.
Right.
then
I see all the arguments are made to 32200, but I wanted to make sure there wasn't an argument that 8.060 is actually the applicable rule we should be analyzing under in the juvenile rules.
I don't believe so. It appears I've gone, if that was a full 20, I've gone way over my time.
No, you've got a couple of minutes of rebuttal.
Okay,
left. Thanks.
thank you.
Miss Alexander? Whenever you're ready, ma'am.
Good morning, Tana Alexander with the Office of the Attorney General here on behalf of the appellee. May it please the court, counsel. So it seemed like through the transcript in regards to the discovery, defense counsel expected to receive the child pornography through regular discovery means. However, as we've already discussed, in accordance with Florida Rule of Criminal Procedure they're technically not allowed to duplicate or transmit child
I
pornography.
think their issue is not just the duplication of this. I don't think they quibble with the fact that you can't reproduce these videos in accordance with the law. But what about this idea, as council put it, you hit a thing within a thing? So if the notice, like, so let's just eliminate the duplicates, because I don't think that's what he's arguing, but he's arguing insufficient notice. And so is there a place where you can point us in this record where the state disclosed that they were going to rely on these videos and they gave that notice to the other side?
Yes, absolutely. There was actually one page of the police report that was in the record. It seemed like there was a page before and after, but it was just the one page. And in that page, which was given to the defense in May, and the trial did not happen until August, it states, uploaded 5 files determined to be child pornography. And this is from the detective.
Where is that?
I'm sorry, Your Honor.
Where is that in the record?
I don't have the specific page that is in the record.
And counsel, we talk a lot about the images, but there were other things that were entered in exhibit 2, correct? Like there's a legend that shows an upload from C.W. Griggs, correct?
Yes, are you talking about the production order result Legion?
Correct.
Yes, that was a documentation that was attached to the notice of intent. And that had just kind of like data that obviously didn't have descriptive information, but that was attached. Now
But that seems to be an important piece of evidence for the state, correct?
yes, absolutely.
Okay.
I
Was
do
that,
believe
where was that disclosed?
the USB drive with the child pornography.
So a reference to the USB drive in the Marco Island Police Report is how you disclose that there was a legend showing that C.W. Griggs uploaded these images. Is that correct?
Yes, I believe the specific.
So you don't think you have to separately list that you have a legend showing that from a specific address, these images were uploaded?
No, I think the mentioning of in discovery puts defense on notice of what evidence is going to be.
But that goes to
admitted.
Judge Brownlee's point. That's a thing within a thing. You mention it in a police report, correct? It's not
Yes.
mentioned anywhere else.
Correct.
And the police report is it's just the 4 initials of the police department. Report, 4 initials of the police department. And in that report, it mentions a USB, which has certain things in it. It doesn't even separately list in there that you have an item which shows that C.W. Griggs uploaded 4 images.
Correct. I do believe that the defense was on notice and if they could have exercised some reasonable diligence, it would have led them to the USB drive, which was listed in property and evidence.
So let's talk about just the rules and whether it's 3.220, which governs criminal felony proceedings, or 8.060, which governs juvenile proceedings. We can agree that the relevant portions of the rules are identical, correct?
Yes.
Yeah, so I see 2 that are a potential problem for
Mhm.
you. One is whether there has been any search or seizure and any document related thereto. And the second one is K, any tangible papers or objects that the petitioner intends to use in the hearing and that were not obtained from or belong to the child. Now, you started your discussion by talking about the 4 child pornographic images. I don't think anybody's arguing that you couldn't send those through the mail or print them off on your office copier and hand them to defense counsel. But am I wrong? I don't think I am, that the return from that warrant was far more expansive than that. That's the first question.
I don't believe, well, the return warrant, it did have additional information and that was.
Far more expansive, right? It had logs that the law enforcement was able to use to independently, separate from his confession, connect KD to controlling those particular images, correct?
Well, also hit Katie's admissions as well.
I said that.
Yeah.
So other than that, it had the log that basically corroborated that, correct?
Yes.
And in addition to those 4 images, there were basically every single kick transaction that Katie did,
Mhm,
correct?
mhm.
So it's more than just those particular images. Fair?
I cannot state specifically. I can't determine what from the regions.
Well, it's in exhibit 2. Exhibit 2 is just not 4 pictures of child pornography. It's a whole bunch of other stuff, correct?
Yeah, all I can say is that the state, they did file several amended petitions in this case. I don't know if they were maybe intending on proceeding on more images, if they had more images on the.
I'm not asking you that. I'm just asking you to agree that it was more than 4 images.
It possibly could.
Well, it's exhibit 2. It's in our record. I'll tell
Yeah.
you that it is. So beyond that, you now have a situation where there is a return of documents in response to a warrant, correct?
Yes,
So the disclosure is SW for search warrant, and it mentions pictures taken of the house because there were other search warrants that were executed in this case, correct?
Yes,
All right. And then below that, and Judge Nardello was referencing this earlier, you have the acronym reference to the Marco Island Police Department, and then you have another SW. How are you supposed to know if you're defense counsel whether the SW relates to the search of the house in which the pictures were disclosed and the search warrant as served on Kick when the word Kick isn't mentioned in that May 9th disclosure?
yeah, I think that defense counsel, even if they did not receive child pornography through the child's phone or computers, obviously there's no evidence to bring forth charges of child pornography. So I think that defense counsel would have expected that there had to be some type of secondary information that would have been brought forth for the state to be able to prove the charges.
I think that's fair, but would they know about all those other logs and all of that other information that was going to independently tie KD to that pornography?
When you're referring to logs, which specific logs?
The stuff that I was talking to you about in Exhibit 2 in our record.
The regions report?
Everything that's in there as it relates to Kick in terms of the logs that were on his devices.
I'm sorry, and your question is, Your Honor?
My question is how would you know about that?
Oh, I think.
Because your point is, hey, we're charging child porn. They should know there's child porn around here someplace and ask to see it or ask to look at it. But what I'm saying is, how would they know about all that other stuff?
Through the police report,
Okay.
where it did state it actually talked about the depictions of the child pornography. It talked about the specific.
Counsel,
acts.
how do we know that?
It's in the record.
It is?
Yes.
The police report's in the record?
There's one page of a report, page 3.
I would
Do you
love
have
it if you had that
I know,
page.
I apologize, Your Honor.
Can you? Are you able to find it?
I don't have,
I would not know. I have.
yeah,
First
Okay.
page of Marco Island Police Report,
Okay.
first 3 pages of the record.
Oh, okay. Fair enough.
Page 3 references.
If that's it, then I don't think that mentions the USB drive, but I can look.
it doesn't mention the USB drive, but the state did state on the record, and I don't know if they were referring to a different page that was part of the police report, that the detective said, I received data from Kick pursuant to the search warrant. The original was placed on a USB drive and deposited into evidence.
Yeah, I think that's not in the record. I think that's a statement of counsel in the trial transcript.
And I would
Unless you're in
agree
a, yeah, unless
I
you're in
would
a
agree with
position.
the court on that. But again, also in the police report, there is a folder and evidence pertaining to Kick that had 5 documents, uploaded 5 files determined to be child pornography. And again, the sexual depictions as well as the perception of the age of the participants in that child pornography.
Right, and I'm not gonna go back to our last interchange because there's more. But let's assume that trial counsel, the state knew that that disclosure was deficient, so tried to remedy it by issuing something the morning of trial. Because there's an amended notice of disclosure, and it says Kick subpoena, correct?
Are you referring to the notice of intent and the certification?
Nope, I'm referring to the notice of supplemental discovery filed. It's dated the day before trial, but the record reflects that it was served the morning of trial. So it refers to it as a subpoena and not a warrant, correct?
Are you referring to I believe it was a search warrant? Information related to the search warrant?
No, ma'am, I'm referring to supplemental record 2. Page 132 of the second supplemental record. The state hereby discloses witness/Kick subpoena returns.
Okay,
Would you know that that was a warrant return?
yes.
How? Do we read subpoena as interchangeable with warrant?
No, but it says search warrant in the police report. So
But how do you tie that to that?
tie the search warrant to what they received from Kick.
How do you tie the disclosure the morning of trial that says subpoena to a police report that references a USB drive contained in a warrant?
I don't believe the police report was given the morning before trial.
Keep going.
It was disclosed in May. I don't know, I'm not sure what the court is referring to regarding the subpoena.
I think that the
That's it.
problem is, it seems like we're talking about 2 different things. And so if on the morning of trial or even on the eve of trial, there seem to be these pieces that are handed to defense counsel. And the expectation seems to be, well, if he's doing his reasonable diligence, he'll put all of these pieces together and be able to complete that puzzle And I think what Judge Traver is saying is, aren't all of these pieces really two different things? How would one piece put the defense attorney on notice that another piece is involved and these things are going to come together? I think I've taken that analogy as far as I could, but
Yeah.
what I'm wondering, counsel, is if all of this is disclosed, are you saying that this obviates the need for the state to comply with the discovery rules? At what point do these two forces come to a head? The idea that, well, they've got these puzzle pieces they're put on notice of, although not in accordance with the rule. But anybody acting with reasonable diligence in preparation for trial should be made aware of this. How does that work in tandem with a violation of the discovery rule?
I do agree that the certification and the notice of intent was probably not given to the defense in an ideal or best practice situation, because the statute does require reasonable notice. Additional and part of that statute also requires the defense to have a full and adequate opportunity to view the evidence. And defense counsel has the right to object to that evidence coming into trial, prior to trial. That's part of the statute.
But that we're just talking about certification, correct, at this point?
Right, well, she was mentioning some of the things that were
Sure.
given prior to, so that was Florida statute 90.8036C. So I do believe that in looking at that, the defense did have a fair and adequate opportunity to view the evidence. And they did also have the opportunity to object prior to trial. When they were getting ready for trial, defense counsel stated twice on the record that they were ready to proceed. And then right before the state called their first witness, the court said, is there any other additional preliminary matters? And defense counsel said no. So I do believe at that time, they could have made an objection to the court. Hey, we weren't given reasonable notice of this documentation coming into evidence. We're not prepared for what it is, and could have objected and asked for a continuance. The state did state on the record that they would not object to continuing the trial that day. And again, it's a juvenile trial. There was a jury that was selected or anything in regard to that.
But didn't the defense try to bring this all to the trial court's attention, at least at one point, by asking for the Richardson hearing and stating that there was a discovery violation?
Yes, they did. But defense counsel was also on notice of what the statute required for the objection prior to trial. And what defense counsel stated on the record is, well, we just kind of got this, and I believe the trial occurred in the afternoon. We researched, and he said, we researched it all morning. We did not have time to file a written motion, and that was because of the state's delay.
I think that conflates the business record statute with the discovery.
Yes,
Rule.
which I do understand is two different things.
Is it your
Um,
position that you can have a discovery violation, but as long as you give a business certification, it cures the violation?
No, not necessarily, but I think the discovery violation, and granted, if we're talking about discovery violation from the certification and the notice of intent versus the actual discovery, because I think the actual discovery was available for them to view. And I did want to bring up that case, Teets v. State, that I did cite in my.
Right, counsel, we understand, and that's a testimonial
Okay.
case. Do you have any case where you can have a pass-through disclosure? Instead of disclosing what you actually intend to offer, you disclose another item which talks about what you actually intend to offer. Is there any case in the state of Florida which says that's okay?
I don't have any case to offer to the court this morning.
What's to stop the state in that vein from in their disclosure saying any available evidence can be found from local law enforcement?
Well, that's pretty broad and not specific.
How is it meaningfully different? I mean, I understand that you're going to make the argument that police reports refer to certain things.
Mhm.
And maybe diligent defense counsel has the independent constitutional obligation to chase down all of those particular leads. I understand that argument. And if this is an ineffective assistance case, we're asking different questions. It's not, it's on direct appeal, and the state has discovery obligations under 8.060. So would the state satisfy its discovery obligations if it just said all discoverable information is in the possession of the Marco Island Police Department?
I mean, I don't think that's regular practice per se. That is a little vague, and I do think that it probably would need to be a little bit more specific, which I do think in this case, it was a little bit more specific as far as, what was documented in the police report and what the evidence actually was. I do believe that what you're saying as Your Honor, it probably would be pretty vague to put in the police report.
Even if defense counsel knew that it was literally a one piece of evidence sort of case, and they knew that that was the one piece of evidence that was there, held by the Marco Island Police Department, that still wouldn't be enough from this perspective of the state to follow the rule.
What would,
Just assume that it's a one piece of evidence case, that the only piece of evidence, everybody knows it. State knows it, the defense knows it, defendant knows it. It's a one piece of evidence case, so we can only be referring to one thing that the Marco Island Police Department has. That's still not good enough?
I do think it would probably need to be a little bit specific, but I do think that, yes, they are still being put on notice that there is evidence somewhere. The defense is being put on notice.
Counsel, what does that analysis go toward? Does that go toward the fact there is no discovery violation, or does that go toward the fact that there is no procedural prejudice?
I don't think there is a discovery violation or procedural prejudice.
Okay, let's assume we find there's a discovery violation, so I can ask my second question. How would we say beyond a reasonable doubt that the defense counsel was not procedurally prejudiced? What's your best argument toward that?
Again, I don't think that they would have prepared for trial any differently. We have a possession of child pornography, which is either the child viewed it or possessed it. So I don't.
What if
think
they would
that-
have taken the deposition of the affiant for the business certification and found out that maybe they don't keep records like this. Maybe this was unusual for them to keep these records. That would have been helpful to their case, would it not?
Yes, but they would have to have taken the deposition to discover that.
Could they have retained an expert to analyze those logs to see whether the transactions that were ongoing on Katie's phone at that time happened at times when Katie was using his phone?
Katie actually admitted that he uploaded the documents, subsequently deleted them, and then I believe that phone was sold.
Right. My point is, what if the logs that arguably weren't disclosed showed something different than that?
I don't have an answer for the court on that.
Do you think that it's the defense's obligation at this point to make some showing of procedural prejudice?
Yes.
Why?
Well, I mean, in that Teets case, it does cite a harmless error test, which is again, if appellant was prejudiced, if there was a reasonable possibility a defendant's trial preparation or strategy would have been materially different. And again, I argue to the court that I don't believe it would have been. Either he possessed a child pornography or intentionally viewed it. And he was charged with 4 counts of child pornography. So I assume that the defense would have been prepared that the state was going to be admitting some type of evidence regarding child pornography.
So are those later statements, this whole idea of the procedural prejudice, this idea that they would be on notice that the state would produce child pornography, even though it's not properly stated in accordance with the rule, does that overcome the discovery violation, assuming that there was one, meaning your notice did not comply with the rules of procedure? Either we use the criminal rules or we use the juvenile rules.
And are you referring to the notice of intent and the certification?
I'm not referring to the business records issue. I'm referring to the discovery violation.
And I'm sorry, your question again is?
My question is, are you stating that the procedural prejudice, this harmless error, this idea that the defense would be on notice in any event that the state was going to put forth some evidence of child pornography, that is sufficient to overcome the state's alleged discovery violation?
No, I don't, but I do think that the statements in the police report referring to the specific evidence and where its location was does.
Can we go back to Judge Traver's point? Does the
Yes.
police report refer to all of the evidence that was admitted in Exhibit 2? Can you tell us right now that the police report refers to all of the evidence that was admitted in Exhibit 2?
Yes,
It does.
yes. And I can specifically read what was in that report. I mean, I wrote it verbatim in my notes here.
Is it part of our record?
Yes.
This is the one that's 3 pages into I think it's page 21, maybe
I just don't know. I
21.
do not know that that is part of our record. It's referred to in the trial, but if you're saying it's actually part of our
It is.
record. Okay,
Well, I think that's a pretty big point for us, counsel, but is it your understanding that it is on that 3rd page of the record, which is page 21 of the original record on appeal, is a Marco Island police report.
Yes.
Is your point with regard to this that all of these images were disclosed, or is it your understanding that this police report talks about the USB being put into evidence?
Both. Well, I'm sorry, excuse me, it does not reference the USB.
Okay,
I apologize.
but this is your response to Judge Traver and Judge Nardella's question about, is this all of the evidence? Would this have put them on notice of all of the evidence that the state intends to use?
Yes. I mean, it discusses 5 files. And there was 4 files that were charged. I don't know what the additional file was. But I believe that would have encompassed the 4 files that were charged against the child.
I mean, it doesn't mention kick.
I believe it says folder and evidence pertaining to kick that had 5 documents.
Not in this record. All right, you're past time, man. Thank you.
All right, thank you.
It was correct, Your Honor, that I had gone over, so I don't have a full file.
No, you've got 90 seconds left.
Thank you.
Yeah.
I don't know how defense counsel could have hired an expert to have looked at logs and matched up the times if he never knew about the log.
It's a pretty good procedural prejudice argument, isn't it?
It is,
Okay.
Your Honor. Similarly, and not to be flippant, I appreciate counsel's argument that the rule required, as to the certification, the rule requires you serve it, you have an opportunity to object. I'm trying to imagine a world in which defense counsel could answer the question at the start of trial. Is there anything else, counsel, that needs to be discussed? And defense counsel could reasonably be expected to say, I'd like to object to all of the discovery that I don't know about that they're about to try and use at trial.
Is there, so the only police report that I'm seeing in this record, and there's the record and then there's 2 supplemental records, is the record that Judge Brownlee was referring to on page 21.
Is that the,
It's number 1 on the bottom of the page. It's
Correct.
19 in terms of the PDF. Is that it?
understood? Those 4 pages? I
Yeah.
think I said 1 through 3, but I think it's
Yeah.
actually 1 through 4.
Yeah, but that,
Um,
just so.
That's my understanding.
Just so I'm not missing, so we didn't have a filing issue with some additional supplemental record.
Not to my knowledge, Your Honor.
Okay,
And it does reference 5 files that were determined, but the paragraph immediately prior. And this is what I have that's been, I don't want to say bait stamped, because then I sound like I'm 1,000 years old, but. What the clerk has marked as page 3, a search warrant was obtained for the social media account. That's what it says. I can't find the word kick in there anywhere. Nor does this cure the discovery violation. Subsection K of the criminal rule, or whatever the corresponding counterpart in the delinquency rule, documents and exhibits that the state intends to use at trial or at final disposition hearing have to be disclosed. That's pretty literal. The state was required to give a list. Hey, we intend to use these at the final trial. We don't know from this, maybe the reason defense counsel went to a final disposition hearing and rejected a hypothetical offer to resolve it is because the state never disclosed evidence that was going to be sufficient to prove their case at the hearing.
we kept Miss Alexander up here a little bit longer, and that's about the time that you've been up. Would you like to wrap up quickly?
Thank you, Your Honor, for the opportunity to do that, because I don't want to leave here without saying Child porn is not ever a business record, and the state made decisions to proceed without that live witness and jeopardy attached. And it should be, the defendant should be discharged from this. My concern with the discovery violation argument is that the court's remedy at the very, if you're not inclined to discharge based on that alone, then you've got to vacate the judgment and remand for retrial for discovery violation.
Thank you, counsel.
Thank you.
All right, we'll take the matter under advisement. We have another oral argument set for 10 o'clock and we'll be in recess until that time.